It is May 28th of 2026, and this is the Court Gallery. Some days in court, you have to hear it to believe it. We kick things off with a defendant who got sentenced for a DUI, then decided to celebrate by getting another DUI less than 2 months later. She tells the judge she was just going through a bad time. Later, a defense attorney tries to handle another client's business in the middle of a plea hearing, and the judge is absolutely not having it, leading to one of the most blistering rebukes you will ever hear. And we close with a woman who broke into a home to commit an assault with a firearm, but her version of the story makes her sound like she deserves an award for bravery. From bad excuses to baffling stories, it all starts right now.
All right, and then we are on the record in the matter of the City of Wyandotte for Serenity Ritchie 251237 and 26291.
Good morning, Your Honor, to you and your staff, Attorney Maxwell, Group P number 86012. On behalf of Ms. Ritchie, stands to my right, please state your name for the charge.
All right, good morning. And today is the date scheduled in this matter for probation violation as well as sentencing on your client's plea to an amended charge of operating while visibly impaired, whereby the original charge of operating while intoxicated was dismissed by way of resolution between counsel. The client is currently on probation in this court on the 25 case, which this court sentenced your client on January 15th. And then the current offense date for sentencing on the 26th case that occurred March 7th. So less than 2 months after she was sentenced.
Correct.
All right. And so counsel, let's handle the probation violation first.
Your Honor, as the probation violation, I have discussed this with my client in depth. She understands, she does plead guilty today to that probation violation. That violation being everything stated on the record. She picked up a new case after being sentenced on the prior case, Your Honor.
All right. Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter to the truth, the whole truth, and nothing but the truth?
Yes.
All right. And you heard the allegations, correct?
Yes, Your Honor.
As to the allegation, ma'am, how do you plead?
Guilty.
You've gone over your advice of rights for probation violation purposes with your attorney, correct?
Correct.
All right. Counsel, you on the phone in this matter?
Yes. And I'm just looking at there's a correction I need to make on the, I was trying to make it easier on you so I can point it out, but there's a correction on the PSI that I need to make.
Okay.
Rarely do that, but it's just, it's.
No, that's okay. Okay. And ma'am, you understand that by entering into a plea, you'll be waiving some of those rights.
Yes.
You also understand the possible penalty as a result of your plea.
Yes.
And the recommendation in this matter is to revoke your under advisement status as well as revoke probation, close the case without improvement, correct?
Correct.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
All right, and counsel, if you can please voir dire your client.
Miss Ritchie, is it true that, I'm sorry, can you remind me of the original offense date? Of her,
The original offense date for,
where she was sentenced or convicted on her prior case.
all right. August 23rd of 25 is when the offense occurred. Your client pled guilty on November 19th and then was sentenced on January 15th.
January 15th. Okay. So, and subsequent to January 15th, is it true that on or about 3/7/26, you picked up a new case?
Yes.
And would you agree that at that time of picking up that new case, you were on bond?
Yes.
And was probation?
Yes.
And with one of those conditions of probation, you should not have any new contact with law enforcement.
Yes.
And was one of those to not consume any alcohol or controlled substance?
Yes,
And would you agree that that did occur?
yes,
And that you violated your prohibition?
yes,
Satisfied, Joe?
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation, indicate non-technical violation number 1 will enter. And, we can address sentencing together, I presume, with the, operating or visibly impaired matter. Well, we'll take them separately. Counsel, what would you like me to know regarding the recommendation on the probation violation?
I've been able to review that. There is only one correction I would like to make, and no additions or deletions. That correction, I can't find the specific place, maybe your eyes will be better than mine, but it does report that she makes 1,200 weekly. That's just 1,200 bi-weekly. That's the only correction.
Okay, all right, I understand that. That's on the PSI. We're gonna handle these sentencing separately. So let's talk about the sentencing for the probation violation first.
Oh, Your Honor, I would just,
To revoke under advisement and revoke probation.
Your Honor, I would have to keep her on probation because, and reason being, since she's been on bond, in this case, she's been doing excellent. You've had her on a tether for over 2 months now. She's had no violations. She's had no subsequent violations of any sort. She's reported to probation. She's been doing excellent, Your Honor. She's on a great trajectory. Again, that was not ideal. My client was very forthcoming. There's a reason why she came here and pled guilty. She's been forthcoming with probation at the same time, Your Honor. She understands what went wrong and why she went wrong. It was a tough couple months for my client. It's been a tough year at that, but she's moving in the right direction, Your Honor. I do believe with the help of this court, the aid, I would like her to stay where she's at because I think she's in a great spot. She has great support. She has a great support system. I would ask that this court refrain from removing that status and allow her to continue on probation. I'd like to address the recommendation. I do think, just for the record, Your Honor, the recommendation for the impaired would pair perfectly with what I'm asking for today.
All right.
I apologize. I didn't realize you were doing the probation. We'll come, yeah, first.
Sorry. So, ma'am, I'm quite confused because I think I was very clear at sentencing in January that you weren't to possess or consume any alcohol or drugs unless prescribed. I don't have any documentation to suggest that you had a prescription for alcohol. And not only did you have alcohol that you had consumed, but it was a 0.172. That's a lot of alcohol. So what's going on? Because you have the opportunity to keep this off of your record. And pretty much just, scoffed at the court and said, I really don't care. I'm going to do whatever I want to do.
I was hanging out with wrong people, which I'm no longer in contact with anymore. I'm trying to work on a better path since then.
So those people that you're hanging out with, that was a stronger pull than the court's orders?
It was a really bad time in my life. I apologize. It's never gonna happen again.
Ma'am, I need to understand what this bad time was, to understand why you willingly violated this court's order.
There was a poor judgment on my end. I don't have any excuse that I can say to why I did it. It was just wrong.
Listen, ma'am, I'm trying to understand what was going through your head in March when you said, okay, I'm gonna take a drink. I'm going to take another drink and another drink.
It just happened. And I'm sorry. I don't, like I said, I don't have an excuse on why. I wish I could take it back. I regret it every day.
And I can appreciate all that, ma'am, but you're not answering my question.
I mean, what you're going on? Who are you hanging out with? Don't name the specific names. What were they doing that influenced you at that time?
It was just, they had asked me to go out and it was a poor judgment because they had asked me if I wanted to go out with them and I went out with them and I had a drink and then it led to another drink. It was just,
Are these
One of
people
those
that,
things
are these
you were
people that
hanging out
drink a lot?
they were, and that's why I'm not hanging out with them anymore.
Okay. And did you follow along with whatever they did because you were used to that all the time?
It was when I was who I was hanging out with.
At any point, ma'am, was there a pause in your thought process? Oh, I'm on probation. I'm not allowed to have any alcohol.
Halfway through, but then at that point I had thought since I was already taking a drink that it was already messed up for me.
And then you furthered that thought process by then getting into a vehicle and driving.
It's something I will forever regret.
Ma'am, when an individual is placed on probation, they're given an opportunity to modify their behavior. And then further, when they're on heightened status or 771.1 status, a deferred or delayed sentencing status, it's a further opportunity to prevent this matter from staying on your record. And what appears to me is that you just took that opportunity and just blew it off. Like no big deal.
Your Honor, if I might too, just briefly, I know my client agrees and she understands that she was given an opportunity, the court put her faith. I don't think it's no big deal to her. I would just like to speak because I know she's nervous right now as well. I know she's been dreading this because she's been talking to me and the reason why I don't want her lack of explanation to reflect that doesn't care and or doesn't acknowledge. I think she's trying to convey that there is no reason for it. She made a very poor decision. She feels very badly about it, Your Honor. I think it's very clear, especially when I've talked to her, is that she just doesn't want to come in here and make a bunch of excuses and reasons. I think she doesn't have one, meaning that she messed up. It's plain and simple. She's got to reap what she sowed. She's willing to do that. She's willing to put in the work to improve from that, Your Honor. I just wanted that to be clear.
All right, thank you. What I'm going to do, ma'am, is I will give you one last opportunity. One. If there is one more violation on this or the subsequent one I'm sentencing you on, there will be mandatory jail time and mandatory revocation of your under advisement status. Counsel, are you texting right now?
No, Your Honor. I'm trying to just pull up.
Am I
If
clear?
you want to put my phone away completely, it's on my PSI.
Okay.
So I'll put it away if you want.
Am I clear on that, ma'am?
Yes.
So I'm going to order that your probation will be extended 6 months from today. Your probation will continue with all the terms and conditions. The court's going to order 10 days jail suspended. And as I already stated, the mandatory revocation and mandatory jail for any future violation. You don't have any other pending matters, do you, ma'am? Other than the Wyandotte?
Just
Yeah.
just
Okay, and then counsel as to the PSI on the OWVI, please.
Your Honor, I just pull this back up on my phone. Is that okay?
Yes.
I just want to make sure. if I put it on the table, it's gonna vibrate too much, so I didn't.
Okay, you can always silence it, just so you know.
Still, we're good. Either way, Your Honor, there are no additions, corrections. There's one correction I would like to make just for the record, that being that my client makes $1,200 bi-weekly, not weekly. Other than that, Your Honor, no additions, corrections, or deletions that need to be made. I have had ample time to go over it with my client. You should have the court's ready to hear it.
All right, you may proceed, counsel.
Again, it's gonna tail a lot onto what we just discussed, Your Honor. Since we did the probation violation first, my client knows why she's here, what she did wrong. Clearly, she resorts to alcohol as a problem, and clearly this probation is addressing that. I do believe it to be just and fair. Your Honor, I would ask that this court consider, in lieu of a tether, allow my client to have a sober link and or, increased testing. She has been on tether for over 2 months with no violations, no problems. That prior violation we dealt with was her first violation. She's getting the picture, Your Honor. I'll just be plain and simple. She's getting the picture. She understands it. By you even giving her a chance, she's very lucky to have that, and she will not squander it, and she will do anything you ask of her, anything you instruct her, and any rule, sanction, or requirement you have, she will meet, and she will do it great, Your Honor.
All right. And so, ma'am, if you were to test right now, what is in your system?
Nothing.
Do you find that the alcohol tether is beneficial to you, not consuming alcohol?
I feel like I can control without having the tether on, but having it on, I have not consumed anything.
And so these people that you speak of that you no longer are associating with, have you blocked them on your phone and social media, or how,
Yeah.
hold on, please, only one of us can speak at a time. Or how is it that you're no longer associating with them?
I don't have them on social media. I don't talk to them at all.
You've now been in trouble twice in 6 months. Right, your first offense was fighting in August, involved alcohol, 0.14. This one now, you were driving after you consumed alcohol, 0.172. Do you see a pattern? What's that pattern?
Alcohol.
Right? The court will find, after hearing from counsel, hearing from Ms. Rich, reviewing the report, the recommendation that there is reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Ms. Ritchie and the legislative guidelines. The court's going to order 18 months probation. I know the recommendation is 15 months. I think that is commensurate with what's been going on. The court's going to find that you are eligible for early discharge, which I will go over shortly. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You'll have to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition, ma'am, is so that you can have some coping mechanisms provided to you so that you can maintain sobriety, hopefully preventing this matter from happening again. You will also have to participate in the MAD Victim Impact Panel. The rehabilitative goal for that condition, ma'am, is so you can further increase your understanding of the dangers of driving while under the influence and the consequences of such behavior. And then you are to participate in 5 days on the court workforce. The rehabilitative goal for that condition is so you can further develop life skills and get back to the community. The alcohol tether may be removed. Any questions regarding those conditions?
No.
$300 fine, $100 screening assessment fee, $900 supervision oversight fee, that's $50 a month at 18 months. And since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, workforce is $200. That's 5 days at $40 a day, for a total of $1,925. You did post a bond, which can be applied to that, and then you will set up your payment plan through probation. As I did indicate, ma'am, you are eligible for early discharge as long as all of the following have been completed. You've had at least 3 months without any violations. You've completed all of your probation requirements. You also have completed at least half of your original term of probation, and all monies have been either paid in full or you've made good faith effort toward making full payment.
Thank you.
Good luck to you, ma'am. Have a seat in probation. Somebody will be with you shortly.
Thank you, Your Honor. Just briefly, I appreciate this court having faith in my client. I just say to my client as well, I think this court has full faith in this is why they're doing this. They're here to help you, not hurt you. And I think they have faith that you can do this. Otherwise, they wouldn't do this. So you have their support. And I think this court realizes that she has every opportunity and ability to do it. She's going to get it done. I appreciate that, Your Honor. Thank
All
you.
right. Thank you, counsel.
Great to see you guys as always. I'll see you next time.
All right. Thank you. Have a good day. Okay, we are on the record in the matter of the state of Michigan versus Rosemary Ferris, 172818, 171534, 171009.
Morning, Your Honor. For the record, Justin Barnett, appearing on behalf of Rosemary Ferris, stating me for the record.
Rosemary Ferris.
Okay, thank you. Counsel, your P number, please.
61808.
Okay, and so you filed an appearance in these matters,
Yes, she needs to be arraigned on 3 separate files.
correct?
2 city cases and 1 state law.
The 171009 is City of Riverview, and the City of Wyandotte is 171534. Well, you've hit all jurisdictions, the state, the City of Wyandotte, and the City of Riverview.
They're all very old, yes,
So you're also, just so you're aware, going to have 3 separate court dates.
I'm aware,
All
unfortunately.
right. Okay, so, as to the arraignment counsel on all of these matters,
If people waive any, stay on you.
the court will waive the formal reading as to all matters. As to the state matter, ma'am, you do understand that you do have the right to have you do have the right to have an attorney representing you, and if you're unable to afford an attorney, you may request to have one appointed to you. You have in fact exercised your right to retain your own attorney, correct? And you've had an opportunity to speak to your attorney regarding all of this as well, correct? I'm sorry?
Correct.
You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, ma'am?
Yes, ma'am.
All right. The court is going to enter a plea of not guilty on your behalf on all of these matters. Schedule these matters for pretrial. Well, the city case is for pretrial, the state case for probable cause conference. And we're gonna get all these dates here in just a moment.
The PCC will be June 4th at 9:45.
June 4th at 9:45 a.m.
You're I have to be in another court that morning.
Which court?
Troy.
What time is that?
9.
Okay, would you like to come here at 11?
Well, that was gonna be my next question on these matters. If the court would allow me to do these on Zoom,
Not anymore. We're, as of June 1st, we're in person only. There's been too many issues we've had, so it slows the docket significantly. And so it's in person only. You can amend it to 11:30.
Yeah, that's fine. I'm
Is that-
coming from an hour away. I live in Clarkston, so it's just, it would be nice, but I understand. So yeah, we can do,
Does 11:30 work for us, Ally?
the PTP 11:30.
10.
Okay.
Riverview, and we do 8 at 10:45.
June 8th at 10:45, council?
Riverview, June 8th at 10:45. Okay. That works.
And then, which is the driving while license suspended. Oh, well, they're both driving while license suspended. Okay. And then the Wyandotte case will be
July
I'm sorry, I didn't hear that. July what?
8 at 10:15.
July 8th. 10:15,
Yes.
that works here.
All right. And so then as to bond.
Yes, Your Honor. My client is 32 years old. She currently lives in Lincoln Park with her father and their 2 children. She's employed as a waitress at Ichiban and Taylor. These cases all arose, I believe, 2017. I was contacted by my client and mother to help her get her driver's license, and her record showed a civil hold. So I was just going through all the down the area reports because I knew she lived down here. And when I got to this court, I found these cases. My client had no knowledge whatsoever of the felony. She does recall getting tickets for the driving suspended back then around 2017. But the felony charge she had no idea about and was completely shocked. So we immediately contacted the court, arranged to turn herself in. So obviously she hasn't been in any trouble since then. Otherwise, these warrants would have popped up and she would have been brought in here in handcuffs. The fact that she has retained counsel, she did turn herself in. She hasn't been in trouble. I don't believe her to be, and she has a stable residence and job. I don't believe her to be a flight risk or a danger to the community. We ask the court to assess personal bonds in these matters.
So counsel, one of my confusions is that it appears as though your client had a matter out of Oakland County.
Around the same time, in 2018, I'm showing the conviction for that.
Right, so I'm not clear as to how these matters didn't pop up for your client during that time.
Now, I don't know when the warrant was issued. I know the offense happened in, but I don't know when it was 1, 2, or.
The warrant was issued July 28th of 2017.
But I did not represent her in those. I'm trying to figure out that Oakland County case, Your Honor. It's a suppressed file. So I've been going round and round with Oakland County Circuit trying to get some information.
Counsel, can you step over that, please? Thank
Sorry.
you.
So I don't even know if that case is open or not anymore, Your Honor. So I don't know the dates that were involved. She had a 7411 on that.
Haida.
Was that Haida? Okay. So you obviously have some more information than me. Is there an active hold on the case or what? Like I said, I've been.
No, it shows 1 year probation. So that's why I'm curious as to how these warrants didn't pop up while your client was on probation.
I don't know either. I have no idea. Because if I would have gotten in trouble sometime around then, I've never gotten pulled back over here, ever.
Yeah, probation or that court never said a word about it.
And then also there was something in Macomb County from 2019, ma'am, traffic offense, misdemeanor, maybe driving while suspended. Did you resolve that?
Car accident sometime around then, but I never got pulled back over here ever around then.
Okay, that wasn't my question.
She wants.
Did you complete that matter or is that matter still pending?
I'm not sure. I don't know.
Yeah, I didn't even know about that one. It was probably a traffic matter. Does it say?
What, misdemeanor traffic offense? That's why but that's all the information I have on that.
Doesn't say the city of the court.
Does Macomb County,
Is it Macomb County?
Macomb County Sheriff, so I don't know. But to your point, counsel, you said she hasn't been in trouble since 2017 is not accurate because that was 2019.
I wasn't aware of Macomb County when that. I'm sorry. Like I said, I wasn't even expecting all these until I started doing some research and, fortunately, there's no centralized system available to us to find everything she has. So I went through every court and I came up with these. Does it say, Your Honor, if I may ask about the Oakland County matter, does it even say if the file's open or closed on it? Like I said, I'm trying to find
It
it.
doesn't say it's open. I just
Okay. Your probation.
I was curious as to whether, since your client was on probation, how she would not have known about these warrants, because I would presume that before she was discharged from probation, there would have been a report run that would have shown your client's criminal history and it would have popped up.
Your Honor, I've been doing
I
it
don't
for a
know.
long time and a lot of things cease to confuse me with probation departments and courts.
All right. And so, ma'am, do you know Caitlin Fay?
Yes,
And who is Caitlin Fay?
she is, my best friend's ex-girlfriend.
So you don't have any reason to have any contact with Caitlin Fay, do you?
I don't anymore, no.
I believe she moved out of state as well, Your Honor. And there is a co-defendant. I don't know if you were aware of that.
Would that be Josh Olick?
Yes, that's my client's former boyfriend.
Okay, well, I don't know that he's ever appeared either. I don't know.
I don't believe so. When I looked at the case up, it still showed open warrant.
What's the status of your license, ma'am?
I believe it's still suspended.
So the suspension, what I alluded to earlier with the civil, that was out of Woodhaven District Court. That was for a civil judgment. We have made contact with the attorney's office on that matter. We provided information. They told me that if she makes a down payment and gets on a payment plan, they will lift that hold. We provided all that information, so I'm just waiting to hear back. I'm hoping that once that's resolved, I can get her a valid license before we come back to DWI
All right, and so ma'am, how'd you get here today?
for next year.
Okay, and how do you get back and forth to work?
My father takes me
Okay, and how old are your children?
8 and 3.
All right. The court's going to take into account that your client has retained counsel, has appeared here in person for all of these matters. 9 years later is better late than never. The court's going to order on the 172818 a $10,000 personal bond. The 171534 $7,500 personal bond. And on the 1009 $7,500 personal bond. The following bond conditions for all cases. You are not to have any contact with Caitlin Fay. That's phone contact, text message, email, social media, third party, anything of the like. You also, ma'am, are not operating a motor vehicle without a valid license. Just have a seat. You'll get a copy of your bond conditions. And then we'll see you back on these matters.
Thank you.
3 different times. Okay.
Your Honor.
Thank you. And sir, do you have that to pay today or do you need a payment plan? I'm sorry?
I'm good with it.
Okay. All right. If you can stop at the window and somebody will be with you shortly. Okay. Thank you, sir. Good luck to you. And then we are on the record in the matter of the state of Michigan versus Ashley Milton, 26615.
Good morning, Judge. Nice and gay for behalf of my patient. He's 7-3-5. It's not step of the 40 state full length.
Actually, no, thanks.
All right. Good morning to you both. Today's date scheduled for the arraignment and pretrial in this matter, and counsel as to the arraignment.
Stand up, wait readings.
Okay. Are you picking them up, Ally?
I
Okay. The court will wait the formal reading, enter a plea of not guilty for purposes of the arraignment. And then as to the pretrial counsel.
Judge, we're asking for an adjournment to review some discovery.
Are you in receipt of the discovery counsel?
Yes,
Okay. All right. And how long are you requesting counsel?
the next Wednesday that I'll be here would be July 2nd, Judge.
Okay.
I'm sorry, I apologize. The next Thursday I'd be here.
Thursdays. Okay. All right, July 2nd at
8:45.
8:45 a.m. as to bond counsel.
Judge, Ms. Milton did post a $500 cash bond initially. So we are asking the court to take that into consideration when doing the bond claim.
I'm sorry, you trailed off at the end. What was that?
We're asking you to take that into consideration. She did post a $500 cash bond. So we're asking the court to take that into consideration and continue the bond judge.
All right. Ma'am, are you currently on probation or parole anywhere?
No,
Have you ever failed to appear in court for any reason?
no,
What's the status of your driver's license?
it's valid.
If you were to test right now, ma'am, what is in your system?
But,
When's the last time you consumed any alcohol?
it doesn't, I don't remember. Actually,
Have you consumed anything after the date of the?
no,
All right. And you're not on probation or parole anywhere, correct?
no,
And you're not out on bond in any other jurisdiction?
no,
And where do you work, ma'am?
I don't work right now.
All right. And how are you supporting yourself?
My husband worked, for the post office and my son receives, exercise.
How old is your son?
He's 4.
Okay. The court's going to order you not to possess or consume any alcohol or drugs unless prescribed, and the court's going to also order you to obtain an alcohol tether from Wayne County Jail.
Okay.
So you'll go over to probation to receive information about going down there to report to receive the tether. You won't have to be taken into custody for that, and the court will continue your cash bond. The levels in this matter are alleged to be fairly high, and it's a second offense. So the court wants to make sure that the safety of the public is upheld to the best that it can. Thank you.
Thank you.
Have a good day.
We will go on the record in the matter 25 CF 115, State of Wisconsin versus Dylan McCarthy. The state appears through District Attorney Kevin Schmidt in person. Mr. McCarthy appears in person with his counsel Glenn Keane by video conferencing. We're set for a tentative plea and sentencing. Is this matter proceeding as such, Mr. Keane?
Yes, Your Honor, and I just filed the plea paperwork shortly. I apologize for the lateness on it. I was trying to contact my other client for this afternoon, and I'd sent the proof of that to ADA Velar instead. And it called for a reduction to a misdemeanor upon proof of completion of treatment. Mr. McCarthy has that. I don't know if he's had a chance to present that to District Attorney Schmidt for his review.
Why don't you go show Mr. Schmidt?
I've already gotten it.
Okay, you're
Okay.
good to go. All right, so all I'm waiting for is the plea questionnaire, which has now come through. Okay, and so what kind of treatment did you complete?
CSG SUD and substance abuse, cognitive behavioral therapy skills, and substance use disorder group. I did a few of them, but this was the most recent one.
Oh, good, I'm glad to hear that. How many weeks and things were they?
The inpatient was 30 days, and then I went to the intensive outpatient was a 12-week course.
And how are you feeling?
Good.
Good, I'm glad to hear it.
Thank you.
Okay, formal motion to amend from count. Which one would you be amending?
I need to know what it says on the plea questionnaire.
Well,
Oh,
It
sorry,
says-
it would be sorry, Your Honor, it would be amending
But
the
it's-
possession of narcotic drugs to possession of amphetamine. And DRI the others.
okay, I was just confused because there's not a possession of methamphetamine charge, it's the narcotic drugs, so. I was just confused about that. I believe it's count 1, so a motion to amend count 1 to an amphetamine.
So made.
Okay. Granted. So I do have the plea questionnaire waiver of rights form in front of me, and it appears that you signed that document. Is that accurate?
Yes, Your Honor. I'm a little confused about why it says amphetamine on there. I don't know if that's a legal term or something, but there wasn't any thing of that involved in the
The
case.
offer in the case was a misdemeanor. I would have assumed we maybe would have done a different one.
I would think so too, because that totally shocked me when I saw that, because And
Okay.
like, there's not a possession of methamphetamine here.
Right.
And so
Right.
honestly, if you're gonna get the credit of having a misdemeanor,
Okay, yeah,
So-
that's the one I found in there was a misdemeanor in the statute, but if there's a different one the DA was thinking of, I'd certainly,
Sure, one sec.
and here's the deal. Mr. Keen went over everything else with you on that plea questionnaire, correct?
Yes, Your Honor.
And so I can go over, if it is amended to something else, I can go over all of that and what that means to make sure that you understand, okay?
Yes, Your Honor.
What I would suggest instead is fentanyl is a drug that can be prescribed. So instead doing possession of an illegally obtained prescription, 450.11 sub 7 sub H.
Okay, that sounds much better to me.
Yes, Your Honor.
Okay, did you get that? Okay. All right. You okay with that, Mr. Keen?
yes, Your Honor. And that has a lower penalty than the other, if I recall correctly. I'm just pulling it up, just to refresh me.
It's an unclassified misdemeanor with a penalty of $500 and or 6 months jail.
Okay.
Okay, yeah.
Okay, so, Mr. McCarthy. Now, discarding the charge and the maximum penalties that Mr. Keen went over with you, he went over everything else with you thoroughly,
Yes, Your Honor.
essentially word for word,
Yes, Your Honor.
and you understand everything completely?
Yes, Your Honor.
You're 27, you can read, write, you understand the English language, high school diploma or equivalent, no alcohol, drugs, or medications.
Yes, Your Honor.
Are you receiving any treatment for a mental illness or disorder?
No, Your Honor, this, I completed that through this.
Excellent. And on that document, there's a list of constitutional rights. Did Mr. Keen go over those rights with you thoroughly?
Yes, Your Honor.
Do you understand that once you plead guilty, you're waiving and giving up those rights?
Yes, Your Honor.
Do you need me to go over those rights with you in any more detail?
I do not.
You understand them and that you're giving them up?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand that here, it's possession of an elite, possession of a prescription or prescription illegally? I need to get that real name down. What is the name of the possession?
Possession of a prescription drug without a valid prescription.
Prescription. Okay, so do you understand that you were being charged with possession of a prescription drug without having a valid prescription?
Yes, Your Honor.
Do you understand that the state would have to prove that you possessed medication that requires a prescription and that you did not have a prescription for that medication?
Yes, Your Honor.
Do you understand the maximum possible penalty could be a fine of up to $500 or 6 months of incarceration or both?
Yes, Your Honor.
Do you also understand that there's an agreement here for costs only and for costs and for 1 year of probation? Do you understand I'm not bound to follow that?
Yes, Your Honor.
Said differently, I could sentence you to the maximum penalty if I thought it was warranted.
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over that criminal complaint with your attorney, that original charging document?
Yes, Your Honor.
And in that document, there's a section called the probable cause section where it basically says what happened that day and why you were charged with the crimes.
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Are you pleading guilty to possession of a prescription without a valid prescription because you're guilty of that?
Yes, Your Honor.
Mr. Keen, may the court use the probable cause section of the criminal complaint to find a factual basis along with the statement made by Mr. McCarthy? You're muted. And Mr. Keen, you're muted. Is he here? Is he there? Is he anywhere? Are you there, Mr. Keen? Can you hear me or no hear me? Nope, I don't think you can hear me. I don't know what you're doing. Are you doing something else during a hearing that you have with me? What in God's green earth were you doing, Mr. Keen? Not paying attention, not being here in our plea and sentencing. What were you doing? Because I know you were talking, I know you were doing something, and you weren't listening.
Your Honor, my apologies. My client for 215 had just called. I had not been able to reach him. I was trying to.
I don't care. I don't
understand, Your Honor.
care. You are literally in the middle of a plea and sentencing. You are not showing respect to your client. You are not showing respect to the court. You are not doing your job.
My apologies, Your Honor. I was trying to make sure I didn't have a client with a missed bond appearance, Your Honor. I was not.
Again,
I understand that.
Cause, not your concern during a plea and sentencing or any other hearing. Otherwise, your butt should never be on Zoom. It should always be in the seat next to your client, because that is so unprofessional. That is so unethical, what you just did. Now, I don't know where you stopped listening and paying attention to the hearing that you're involved in and where you didn't. So now I have to start over. My apologies to you, Mr. McCarthy. Sincerely. Now, Mr. McCarthy, again, I'm going to go over all of this stuff with you. Your attorney, hopefully focusing directly only on you, went over the plea questionnaire waiver of rights with you, correct?
Yes, Your Honor.
And do you believe he went over it thoroughly with you?
Yes, Your Honor.
Do you believe he went over it word for word?
Yes, Your Honor.
And all of those things, again, you're 27, high school diploma, read, write, understand English, no medications, drugs, or alcohol in the last 24 hours.
No, Your Honor.
No mental illnesses or disorders.
No, Your Honor.
Because you're charged with crimes, you're entitled to constitutional rights. Each of those rights is listed on the plea questionnaire. Did your attorney go over those rights with you word for word?
Yes, Your Honor.
And do you understand them completely?
Yes, Your Honor.
Do you understand that by pleading guilty, you're waiving those rights?
Yes, Your Honor.
Do you understand that, or do you need me to go over those rights with you in any more detail?
No, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand that the state would have to prove that you possessed a prescription drug without having a valid prescription?
Yes, Your Honor.
Do you understand the maximum penalty could be a fine of up to $500 or 6 months of incarceration or both?
Yes, Your Honor.
Do you understand that there's the agreement that's been reached for you to have costs and 1 year of probation?
Yes, Your Honor.
Do you understand I'm not bound to follow that?
Yes, Your Honor.
I could sentence you to a maximum penalty if I thought it was warranted. Understand that?
Yes, Your Honor.
Now, your attorney, he went over that criminal complaint with you
Yes, Your Honor.
with those facts that allege what happened that day and why you were charged with the crime.
Yes, Your Honor.
For the most part, are those facts accurate?
They are.
Are you admitting here today, in fact, did possess a prescription drug without a valid prescription?
Yes, Your Honor.
Now, Mr. Keen,
Yes,
may
Your
the
Honor.
court use the probable cause section of the criminal complaint with the statement made by Mr. McCarthy to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you, Mr. McCarthy, for you to plead guilty to this charge?
No, Your Honor.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily.
Yes, Your Honor.
Has your attorney represented you competently?
Yes, Your Honor.
Has he answered all of your questions?
Yes, Your Honor.
Has he looked at this matter thoroughly?
Yes, Your Honor.
At this point in time, are you satisfied with his services?
I am.
Okay. You have any questions for the court or for your attorney before I proceed?
No, Your Honor.
And if I didn't ask this before, he's appearing by video, right? Do you understand you have the right to have him seated right next to you, to sit there and pay attention to what's going on? You
I do.
understand that?
Yes, Your Honor.
And do you and so you are okay with him appearing by video?
Yes, Your Honor.
Any questions for Mr. Keen or the court before I proceed? Because I can send you to a breakout session in our Zoom room, or I can say you can have time to go quick, give your attorney a call if you need that. Any questions?
Not about this, Your Honor.
Okay, then as to amended count, well, formal motion to amend to possessing a prescription drug without a valid prescription.
So made.
Granted. How do you wish to plead to the amended count 1?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the amended count 1. Counts 2, 3, and 4 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
I think at least from Burnett County's perspective, we're mostly concerned with the substances that Mr. McCarthy is using. He doesn't seem to have any criminal history up until 2021 when he gets that fleeing in Washburn County. And then subsequently, he would be convicted of another fleeing in Minnesota in which he had fentanyl and methamphetamine on him, or more precisely, a tinfoil that tested positive for fentanyl, and then some powdery substance that tested positive for methamphetamine. So that was in February. Our case came a few months later. So fentanyl is an extremely dangerous drug. It's very easy to overdose on it. Our concern is making sure people don't get addicted to it. It's extremely addictive too. So this disposition shows that because of the things he's already done, we don't need to pile on with more felony convictions. However, we still have some supervision to make sure that we're making sure that he can have the tools he needs to defeat that. Thank you.
Thank you. Mr. Keen.
Yes, Your Honor. I'd encourage the court to adopt the recommendation because, as the DA pointed out, there's mostly a substance abuse issue, and Mr. McCarthy has worked diligently over the past, several months plus, taking advantage of his, used his, taking advantage of benefit available to him as a veteran to get inpatient treatment through the VA, along with outpatient treatment, and he's been doing that so that he can, take custody and care for his child, and be involved in the child's life. And Mr. McCarthy has managed for since coming back into compliance with the court, he's managed to avoid further legal trouble while completing treatment, which, as the court and the DA is well aware, is not always easy when you're trying to overcome substance abuse disorders over the length of this case. And I think the fact that he's managed to do that while making it to treatment other things is proof that a probation to provide continued supervision over Mr. McCarthy is an appropriate result for this court. Thank you, Your Honor.
Thank you. Mr. McCarthy, is there anything you want to tell me you want me to know about this and about you?
I know we touched on the substance abuse stuff, and that is just one of the biggest things that I'm proud of at this point is staying sober and remaining sober. And that is not anything I think the court or anybody has to worry about. And it's upmost on my mind, but I don't, I just see good things coming. So I appreciate your guys' help with everything also.
How long have you been sober?
Since August 5th of last year was the last time that I used fentanyl. So I'm coming up on a year.
I'm so proud of you.
Thank you.
That is something to be very proud of. You're a veteran?
Yes, Your Honor.
Where did you serve?
In Washington State, and I did training in Fort Leonard Wood in Missouri, and then I was stationed in Washington State.
Okay. How long were you in this service?
2 years and some change. It wasn't very long.
And so you have access to VA resources?
Yes, Your Honor.
Are you on probation anywhere else?
Just in this county.
In this county?
So I got put on probation in Minnesota, and then they transferred me over here. So technically I am on probation in Minnesota, but I just am handled by Burnett County for probation.
Yep, I understand that. Okay, that's good to know. So in Minnesota, what were you convicted of?
The fleeing and evading.
And how long were you on probation?
2 years in Minnesota. Or I think Minnesota had given me 3 years.
So when's your discharge date?
2030.
Okay. And the fleeing, when did that happen?
In February of 2023, I think, in Minnesota.
What happened? Why'd you flee?
I was scared. I was homeless. I was on drugs. I didn't want to go to jail. I was just making the wrong decisions. I think the biggest thing that contributed to that was the substance abuse.
You have kids?
I do not.
You do not have kids?
No, I got the DNA test back, and it turns out that I was not the father of the baby boy. So
It could be sad, it could be glad.
yep,
Both could be either.
right.
You have a home?
Yes, Your Honor.
Who do you live with?
Richard Cook.
You sober?
Yes.
Good friend?
Yes.
You have a sober network?
I do.
Who?
The guy I live with, I met him when I was in treatment in St. Cloud in VA. That's how I had linked up with him.
That's why you moved here?
That is how I met Rich.
Okay, but why did you move to Burnett County? Oh my God, I remember.
Mm-hmm.
Just dawned on me who you are.
Yep.
Yeah, sad. For the baby thing.
Yeah. Yes, Your Honor.
Well, it looks like you're doing good. And your mom?
Doing well.
And she's sober and she's strong in there.
Yes, she is.
Seems like a very great woman.
She is.
Okay. Okay. And I forget where she lives.
Cable.
Yeah. So it's close, but not close.
Yep.
Okay. You go to any sober groups?
I was attending AA and going to the Compassion House, and I was attending them. Now the weather's been nice. I've been doing a lot of stuff outside, so I should probably go start back and attending them again. But I was hitting them all the spots that are available in the area.
So you know what your triggers are and what makes you crave substances?
Yes, Your Honor.
Want to explain? Want to talk? You don't have to, but
My triggers for me are, it could be people, certain people that I hang around. My mood, my environment.
if you get triggered, what's the plan?
I call my family, my little brother, my sister. I FaceTime them if anything's not going how it should for me.
You need probation?
I think I wouldn't say no to that. I think having probation there as a helping stepping stone would be good for me. Having resources in the community.
Sounds like you have access to a lot of resources.
Yes, Your Honor.
So are you saying that you think probation could be another helping hand?
Yes, Your Honor.
Okay. Want probation, you'll get probation. I was considering not, but because it sounds like you have a very good sober network and access to resources, but I'm not going to deny you if you feel that you need an extra hand.
Thank you.
Okay. All right. So you have went through a lot in the last 5 years, let's say.
Yes,
Okay.
Your Honor.
And I know that from other places, and I'm not going to go into it, but I do have an idea of your history, that you were homeless, and then you came back here, and I'm so glad you met Rich, because it sounds like that's a really good connection for you. I know your mom and your sister, and they seem like very good, solid, upstanding, respectable people. So that's a good source that you can rely on. Use it. Always use it. I don't think you're a threat to the community. Quite honestly, I think you are steps ahead of where someone else could be that is in need of probation. But again, I'm not going to deny it if you want it, honestly. So So what I'm gonna do is I will follow the recommendation, 1 year of probation with conditions of absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, no alcohol. Regular or testing upon agent discretion. Are you working?
Yes, Your Honor.
Where do you work?
With Rich, he does HVAC stuff and I've been, his apprentice or laborer.
That is an excellent field to get into. Excellent. All right, so, and I'm gonna say gainful employment, keep that up, keeps you out of trouble. I'm not gonna order you to go to any AA meetings or other sober meetings. I highly recommend it. So you don't lose that. All right, you have 20 days to appeal. Well, actually, I'm gonna order $443 in fines and fees. We have more than that in bail to cover that. So you get a check back, or whomever posted it will get the money back. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. You must report to probation immediately. But first, you're gonna go to the jail to get your DNA because they need that.
Mhm.
You have the right to request it be expunged through a written letter to the Department of Justice, but Minnesota probably already has it in the CODIS system, so, but you still are free to do that. It's easy to do, Google, and it'll show you how to do it. So go take care of your DNA, go to probation immediately, get that all set up and ready to go. Address still on Kruger Road,
Yes, Your Honor.
telephone ends in 1364.
Yes, Your Honor.
All right. Mr. Schmidt, anything I'm missing?
Nothing from me.
Mr. Keen?
Nothing, Your Honor.
All right, thank you. We are adjourned. You're gonna need a DNA thing to go to the jail. Go get that stuff done. Congratulations, I guess, but I'm commending you. You have done so much work since last August. I'm just so
Thank
proud
you.
of you. Keep it up.
Your Honor, when Mr. Quinn's brought in, can I speak with him privately in a breakout, because we have a resolution of the case after talking to the ADA Schmidt. I mean, with DA Schmidt, sorry. And I just want
Yes.
to have a chance to go over with him.
There you go.
Thank you, Your Honor.
Got 3 cases on Jason, don't I? Right? Jason Smith? Sir. You're here with Mr. Kindler, your attorney and the state's attorney. There are 2 motions to revoke probation in cause number 18-28788 and 18-29417. And to round out the field, we have a new indictment, which is the problem here. You were placed on probation earlier, and then now we jumped up with something that should have never happened. You're alleged to have committed the 1st-degree felony of aggravated robbery, which carries with it up to life in prison. What a mistake. And you're looking at a 2nd-degree felony in 29417, up to 20 years in prison for that, aggravated assault with a deadly weapon, and a 2nd-degree felony for illegal possession of a controlled substance, which, let's see, what is it? Methamphetamine. Hits keep on coming here. Okay, what are we gonna do?
Got it. All right, Judge, I have sent you a dismissal on the new charge.
This one, 25 CR 1015.
Yes, sir.
I don't have it. Oh,
Yeah.
That
was,
okay.
and the reason why you haven't received it yet is it's on yesterday's.
Then what? What are we gonna do on these 2 motions?
The agreement with the defense is he's pleading true to count 2 on the 2 motions.
And then what?
And we are not in agreement as to the disposition.
Well,
So
then
we'll
come
leave
to
it.
me.
It comes to you. Yes, sir.
This first thing is, notwithstanding all of this,
Yes, sir.
this 25 CR 1015 motion to dismiss. All the parties want me to sign it now, correct?
Correct, Judge.
We don't need to wait.
No, sir.
No.
It is dismissed.
Thank you, Your Honor.
In the interest of justice is what it says.
Correct.
Just call me. Two cases, 18-28788 and 18-29417, the state of Texas versus Jason L. Smith. That is you, sir.
Yes, sir.
And with Mr. Kindler, your attorney, the state's attorney. And probation is here for us. Does the defendant waive formal readings of these motions to revoke probation? Can we proceed in summary?
So wait.
Raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Put your hand down. In summary, 28788 states, in summary, that on or about June 21st, 2019, in this criminal district court of Jefferson County, Texas, you were sentenced to 10 years in prison, and that was suspended, and you were probated for 10 years for the second-degree felony of illegal possession of a controlled substance. And as we know, it is methamphetamine here as listed in this indictment. Is all of that true and correct?
Yes.
I'm writing, I noted that in each of these cases, the defendant pleaded true to allegations 2 and 3
That was back in,
back on August of last year. And
that's correct,
then
Judge.
we did not move forward on that for whatever reason.
If the defendant, the federal government filed a case on him at that time, it was put into federal custody.
Okay.
So
So what are we doing on these two?
we would proceed with
Same thing, Judge.
plea of truth.
Okay.
Proceedings.
In each of these two cases, sir, allegation 2 states, and we can take these up together,
Okay.
that you failed to, in number 2 states, you failed to provide verification of performing community service as required in violation of condition 17 of your probation order, which states, we got another problem. It's misstated on the condition. It says in condition, you failed to perform community service hours in each of these in violation of condition 17 of your probation order. 17 of your order says be inside your home every day from 10 to 6. It's curfew. It has nothing to do with this. Number 15 does say in your community service supervision orders, perform 800 hours of community service restitution. So that's what that is. So that's a mistake. Should be changed to 15. Any objection?
Okay.
Condition 15. All right. Once again, in each of these 2 allegations of these motions to revoke probation, allegation 2 states you failed to provide verification of performing community service hours as required and directed in violation of condition 15 of your probation order. Is all of that true and correct? Are you pleading true and correct to that voluntarily and because it is true as it is alleged?
Yes, sir.
You understand that a voluntarily and knowingly make plea of truth to one or more violations, that's of probation, that is enough to grant a motion to revoke probation. Your probation can be revoked in these 2 cases. And in 28788, you can be sentenced to no less than 2 nor more than 10 years confinement in prison because you were on regular probation for 10 years confinement, suspended for 10 years. And in 29417, your probation could be revoked. You could now be found guilty because you were placed on deferred or unadjudicated probation in that case. And you could be found guilty and sentenced to the full range of punishment of no less than 2 nor more than 20 years confinement in prison. That's a total of 30 years in prison, but collectively. Do you understand what can happen and the consequences that can occur by your pleas of guilty or true to these violations of probation?
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir.
There's one other violation that was earlier pleaded to, and that was number 3. You failed to pay court assessed fees as directed, and you were in arrears $564 in one case and $1,334 in another case, and that's for your probation fees, costs, etc. Were you able to pay those?
Not at the time. I actually run my own business, so I didn't have a lot of work at the time.
So you weren't able to pay those?
No, sir.
What was the date, Your Honor? Of the hearing?
July 3rd of last year.
Last year.
So at that time,
No, sir.
okay. That's about $2,000
Correct.
total. But you had your own business
Yes, sir.
and you couldn't pay that?
No, sir. I didn't have a lot of work coming in at the time,
What was your business?
like construction. I didn't have any clients or any work going on at that time to bring anyone in at the time.
In this town, you couldn't find a construction job?
Yeah,
Okay. Were you trying hard,
absolutely. I'm on Facebook,
sir?
Google. I'm on Facebook and Google. I make posts all the time and I drive around and just look for properties.
All right, what are we gonna do? What, do we have an agreement on anything?
There's no agreement.
No agreement. What do y'all, okay?
I would just observe that since he's been in custody since, I believe, June 28th of 2025, that he's developed. I would say, would it answer?
It actually, they removed it. So I'm in remission from it. I believe is what they consider it.
They have procedures while I was in custody in Houston to remove lymph nodes.
Yeah, my lymph nodes in my growing area. I'm waiting on an MRI for the black spot on my liver, but
Okay, what does that have to do with
Well,
the
just the-
commission of these offenses?
Nothing, Your Honor, just it may be relevant to the court's decision and revocation.
The sympathy move.
Well, the state would have
By
to
the-
pay for its next material. Something that may be considered, out of the court's cognizant. of
Well, of
expenses.
course, if that was it, people would start cutting off their fingers so they don't have to go to jail. I mean, that's, we all have physical issues.
No, it's a rather
But
mercenary,
it,
mercenary.
yeah, it's a Hail Mary throw. But it's, sometimes those things are caught in the end zone, you know? Your misdemeanor history, you've got a Class C theft conviction back in 2014 of evading detention, 90 days in jail, and 14 Class B theft, a second Class B theft, 90 days jail. It's 14 reckless driving. That was deferred and it expired. Okay, that looks like it. Correct, sir?
yes.
How much time does he have? Please, Fred. Okay, the facts on the pre-sentence report, and then I'm gonna let the lawyers send it on fund number 28788, which is this illegal possession of a controlled substance on or about June 15th, 2017. The police stop your vehicle at a as there was information they had that you may be transporting narcotics in a silver Dodge truck, Ram truck. Yeah, that was your truck, I guess. And they smelled the odor of marijuana. You consented to a search. As a result, a plastic baggie with methamphetamine was found in the center console, and then you pleaded guilty to that. But on this 29417, aggravated assault with a deadly weapon, this occurred subsequent to this June 15th incident here, as on October 28th of 2017. 17. Should have been July, August, September, 4 months. At 10:30 PM, let's see. Two people were in the vehicle with an 18-month old child on Nederland Avenue when apparently you pulled up next to their vehicle for whatever reason, pulled out a small caliber handgun with a laser attachment and stated, "I ought to shoot your bitch ass," and then sped off. After dropping the children at a babysitter, the complainant and the other person headed to Beaumont, and then you came up from behind, drove around getting in front of their vehicle, attempted to stop in front of them. And there was a little chase going on at speeds of over 100 miles an hour on Interstate 10. Police were contacted by phone, by the complainants, and let's see. And they were told to meet officers at Parkdale. Apparently, the next day, the incident was reported to Nederland Police Department, and they made contact with you, and then apparently that meeting with the police never occurred. Then the district attorney's office indicted you for aggravated assault with a deadly weapon. And so that's indictment states you knowingly and intentionally threatened the complainant by stating, "I ought to shoot your bitch ass," and then did in there use a deadly weapon, namely a firearm, during the commission of the assault. You pleaded guilty to that. And then you were placed on deferred probation on that case and regular probation on this. This earlier one, the illegal possession of controlled substance. Okay. Go ahead, State. I think I see where we are.
All right, so Judge, I believe the disposition originally on these cases predates me having this caseload. I can tell from the PSI that there was a state jail felony offense originally. In the possession of controlled substance. When you look at that PSI there that stated, it appears that in April of 2018, we dealt with the state jail and the possession charge, and what Your Honor did was order that he do some state jail time and then successfully complete the substance abuse felony punishment. He picks up the aggravated assault charge on October 22nd, 2018. He's granted deferred as all those are operating. And then in 2019, the possession charge is changed over to a straight probation. So that's really the only kind of the procedural changes that occurred there. And I point that out because I believe we've used a lot of resources to try to get his attention, and hopefully he would successfully complete probation. Based upon the pleas are true today, we know that he's failed in that regard. The offenses themselves warrant a prison sentence, specifically the aggravated assault.
He's got, by the way, 602 days credited. Almost 2 years.
Because one of the offenses has a 10-year probated for 10 years, I'm suggesting to the court that he be sentenced to both cases for a term of 8 years to run concurrent.
Oh, go ahead, Mr. Gamble, on behalf of the defendant.
Yes, Your Honor. I think that, again, I don't want to speak out of turn or put words in the state's mouth, but for the new offense that was alleged and then abandoned and dismissed, that perhaps we wouldn't have an MTRP before the court just for community service and administrative violations, which is where we are at this stage. I would agree that if the state had been able to prove up the new aggravated assault, or if the federal government had chosen not to dismiss that case, then this would be in a different posture before the court for revocation. But as it stands now procedurally, what the court has before it is a violation for community service and non-payment of fees, maybe $2,000 a year. So I would just argue that given those circumstances, that revocation at this point would be disproportionate to the violations that have been proved up.
On the aggravated robbery that was alleged.
Yes, sir.
These, what happened on it? That was dismissed or y'all
The
decided?
whole reason why I'm forced to dismiss that is my complaining witness has relocated to Georgia.
Okay, all right.
I talked to
You don't have a
him.
complaining witness available.
I talked to him at the time in which he originally entered this plea in August. He was cooperative then. The state had more than sufficient evidence. I suggested to defense counsel that it would not be a wise decision to move forward with his request for a motion to revoke probation because it would have resulted in points on both of these offense and the sentencing guidelines calculations. He followed my advice and we reset this matter. And had I proved that up, I would have been requesting a minimum. I would have been requesting 20 years on the aggravated assault. So I've taken that into consideration in the request I put before the trial. With respect to Mr. Ham, Your Honor, the factual predicate of the aggravated robbery served as the factual basis of the indictment in federal for carjacking. I believe another offense. That case was set for trial. We were prepared to try the case. After a pretrial conference with Judge Crone, the federal government chose to dismiss that case based upon, for whatever reason, I would assume some sort of evaluation of the facts that were more in line with an actual proving the case up. But I would just say that the same factual predicate that the state is asserting on the aggravated robbery was looked at independently by the federal prosecutor and was evaluated in such a manner that precipitated or necessitated dismissal of the case pending trial.
Okay. From probation, I want to ask you on this failing to provide verification of performing community service hours as required. Can you give me a hint? What has he done, if anything? On that?
Community service.
Yes, ma'am.
He hasn't done any.
None. None. And he was on probation since 2019.
2018, I believe.
In one case and 2018 in the aggravated assault case. And we're talking about a period of time through or what, 6 or 7 years?
Yeah.
Nothing.
Well, he has been incarcerated.
How much of that time has he been incarcerated?
Since June 28th of
It would have been 3. I'd done 2 years in state jail while the probation.
How much time were you free, man? In this period of time from June 21st, 2009, October 22nd, 2018 to today, which is almost 8 years.
5.
Sir?
5.
So there were 3 years then that you were out and about and you didn't do one dime of community service. Okay. Anything else?
Right, see what you
You have a chance to speak if you wish. Go
It's
ahead.
just during that time I was working and actually trying to start my business and I had a family going and things like that. It's just, I didn't have a whole lot of time for that part. I was taking the classes. I've done every class. I've even done the program for them. Only reason why I was behind my fees now is because I didn't have work. But any other time in the past, I've gotten behind my fees from not having work. And every time I've gotten a new job, I paid in full.
How much, since he's been on probation, how much has he been credited for payment on fees, costs, et cetera?
His assessed fees were 10,390, and he's actually paid over 6,150 on one case. And on the other case, he's paid 9,470 total.
Okay.
Now, he's consistently does.
That's not an
pay.
issue. How much, was there any restitution on any of those? There wasn't any restitution on
Not
that?
that I'm aware of.
Okay. All right. Right, what are you asking?
We're asking to be continued, Your Honor, to give an opportunity to speak to probation. Or if the court's not inclined to continue, then consider a sentence at the lower end of the sentencing range.
All right, anything else to add?
No.
If not, I'm going to find in each of these two cases, cause numbers 18-28788 and 29417, that in these motions to revoke probation, first of all, in 28788, the second degree felony of illegal possession of methamphetamine, a controlled substance for which the defendant was sentenced to 10 years in prison, and that was probated for 10 years. That the court finds that there is sufficient evidence supporting this motion to grant it by preponderance of the evidence or greater, as allegation 2 has been proven true, as the defendant has failed to follow that requirement of performing community service hours as required, as the probation office states that the defendant has essentially failed to do any of that. And thus that violation supports the motion to revoke probation in this case, and your probation is hereby revoked. In 18-29417, the defendant was placed on 10 years deferred or unadjudicated probation for the second-degree felony of aggravated assault with a deadly weapon. And he also pleaded true in that case for failing to provide and perform community service hours as required in violation of condition 15 of each of these probation orders in these cases. And again, in that case, essentially no community service hour had been performed over a period of almost 8 years. And thus, I find that a violation of his probation, and this motion to revoke unadjudicated probation in that case is hereby revoked by preponderance of the evidence or greater. In 28788, the court finds, based upon that probation being revoked for his failure to perform his probation requirements, as the court has placed into the record, your probation is hereby revoked. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You'll be given credit for time you have served. In this cause number 18-29417, earlier you were placed on probation, deferred or unadjudicated probation, and now the court grants this motion to revoke unadjudicated probation, and your probation is hereby revoked. Earlier in this case, you pleaded guilty to the second-degree felony of aggravated assault with a deadly weapon. Voluntarily, knowingly, intelligently, there was sufficient evidence supporting your guilty plea at that time to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of that offense based upon the violation of probation. And you were hereby found guilty, and you were sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. These two sentences shall run concurrently. On this case, an affirmative finding is rendered in the judgment that a deadly weapon, namely a firearm, was used in the commission of that offense. And again, you are given credit for what we have here is over 600 days. Do you understand what has happened today, sir?
Yes, sir.
Yeah, it was irresponsible, and you have a family at home.
Absolutely.
You got to think of them, not whatever caused this mess first. They should always come forward first.
Absolutely.
For you. Not, when you make a decision, you got to think how much not only you lose, but the people who depend upon you. We're always third. We're always third. Creator is first. Others are second. You come in third. That's the way it should be.
Absolutely. I couldn't pay. And the community service is on.
Community service, you're not being punished for failing to pay. You did what you could. It's community service, though, is something that you have to show, which fixes this mess. It's a kind of a moral issue, showing that you can help repay, because you can't replace the threatening behavior that people were traumatized over. But community service is a form of kind of trying to fix that by helping the community be a better place. But you didn't do a dime over a period of 8 years. But let's face it, these two offenses, you had no business acting that way. That was very serious.
Absolutely.
All right,
Thank you.
fix it, move on. Thank you.
Before the court calls the next matter, Katie, you are on vacation. You are not supposed to be working. Turn off live streaming and go to the beach. That is an order. Court calls file number 261640FH, and that matter is people of the state of Michigan versus Chad Deming. Mr. Deming, how you doing?
Doing all right. How about you?
All right, Mr. Deming. He's here along with his attorney, Mr. Doug Corwin, our public defender. Mr. Kerner is present. He's our elected prosecutor. I was given a number of documents in anticipation of a plea. Those documents include a plea agreement sheet signed by the attorneys, Mr. Deming. Form of advice of rights also appears to have been signed by Mr. Deming. And then an amended information. Is that an amended information? Is it amended, Mr. Kerner?
No.
I was just given a copy of the information just as a courtesy.
Yes.
Okay, all right, that's nice. I appreciate the courtesy. I
understand the confusion.
That's fine. That's fine. Mr. Deming, would you raise your right hand? Best that you can. Do you promise that you will tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. Hey, Mr. Deming, are you on probation or parole in this court or any other court?
No, I'm not.
Other than the charges that bring us together today, do you have charges pending anywhere else?
No, I do not.
Thank you. Mr. Kerner, do you have terms for us?
I do, Your Honor. The defendant will plead guilty to count 1, possession of methamphetamine. The prosecution does not have an objection to Shiawassee County Drug Court if he's eligible and accepted. In turn, the prosecutor agrees to dismiss the drug double and habitual offender notice. The estimated sentencing guidelines are 5 to 23 months.
Thank you, Mr. Kerner. Mr. Corwin, is that your understanding of the plea agreement?
The plea agreement, yes, Your Honor.
Thank you. Mr. Kerner, would you read that count into the record, please?
Yes, Your Honor. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court, informs the court that on the date and location described above, the defendant did count 1, controlled substance, possession of methamphetamine, ecstasy, did knowingly or intentionally possess methamphetamine, contrary to MCL 333.7403 2B1. This is a felony punishable up to 10 years and or $15,000 and is against the peace and dignity of the state of Michigan.
Thank you, Mr. Kerner. Mr. Deming, I'm told you're willing to plead guilty to possession of methamphetamine. That's count 1. It's also a felony punishable by up to 10 years imprisonment. Is that correct?
Yes, Your Honor.
Mr. Kerner estimates the sentencing guidelines to be on the minimum anywhere from 5 to 23 months. Did you hear him say that?
Yes, Your Honor.
Did you hear him use the word estimate?
Yes.
Well, that's important, Mr. Deming, because the court's going to score the accurate guidelines as we get close to your sentence date. Those are the guidelines that we're going to use. It's important for you to understand that if the court's guidelines are different than Mr. Kerner's, you wouldn't be able to withdraw your plea. Does that make sense to you?
Yes, Your Honor.
Also, the people are not objecting to you receiving consideration or placement into one of its treatment courts. You heard him say that as well?
Yes, Your Honor.
That doesn't automatically mean that you get to be a participant in a treatment court. That just means that the people do not object. It ultimately falls on the court to decide whether or not you will come into a treatment court. I haven't decided whether you will or not, because although I know who you are, I don't know what you've been up to. And I believe we tried before with you, didn't we?
No, Your Honor. No,
didn't we send you to treatment some years ago and you kind of flunked out of it?
I did treatment 3 years ago and I passed. I did all my treatment.
You did your treatment?
Yes, I did. I successfully completed it.
Okay. All right. Well, let's see. Well, I'm not going to decide today whether or not you're going to come into drug court because, well, as you can tell, maybe my memory's not accurate and I'm not sure what happened. I know that we've interacted in a court setting before and I know treatment was involved, but if you say was it in Saginaw?
Yep.
Yeah, I remember that. Okay.
Odyssey House.
Odyssey House. Well, we'll screen you and we'll see. No promises though. I promise you that the process will be fair and we'll take a look. And if it fits and the risk and needs works out and I can conclude that you can be safely managed in the community, then we'll give it a shot. But no promises, okay?
All right. Thank you.
You're welcome. But if the court decides for some reason that you can't come into a treatment court, you wouldn't be able to withdraw your plea on that issue. Do you understand that?
Yeah,
Does all that seem fair to you?
Yes, it does.
Do you have any questions about the terms of the plea?
I don't.
Is that what you want to do?
Yes, I do.
All right. Other than what was placed on the record, has anybody made you any promises to get you to plead guilty today?
Honor.
Mr. Court, you aware of any promises off the record to induce Mr. Deming to plead guilty?
There are none.
Mr. Kerner?
None.
Thank you, Mr. Deming. Has anybody threatened you or any members of your family to get you to plead guilty today? All Are you pleading guilty to possessing methamphetamine because you did in fact possess methamphetamine?
Yes, Your Honor.
Has your attorney, Mr. Corwin, left the final decision as to whether or not to plead guilty up to you?
Yes, Your Honor.
Has he talked to you about the different choices that you have to resolve the matter?
Yes, Your Honor.
Did he explain to you that you have a right to a jury trial and all that entails? Have you concluded, Mr. Deming, that this plea offer made by the people with no objection by the people for treatment court consideration is in your own personal best interest?
Yes, it is.
Mr. Deming, do you understand that once the court accepts your plea and finds you guilty, you give up or you waive your automatic right to appellate review?
Yes, Your Honor.
If you wanted to appeal, you would have to go to another court and ask them for permission or leave to do so. Do you understand that?
Yes, Your Honor.
Any questions so far?
No.
I mentioned an advice of rights form. We look at the form Mr. Corwin gave me. The bottom has a printed name, Chad Deming. There's a signature above it. Is that your signature?
Yes, it is.
Mr. Deming, did you read all the rights that are listed on this form before you signed it?
Yes.
Before you signed the advice of rights form, did your attorney, Mr. Corwin, make himself available to you to answer any questions you might have or address any concerns you may have? Got to wait for me to answer the question. It's okay. I totally lost where I was. Did he make himself available to you to answer any questions that you may have or address any concerns you may have about any of those rights?
Yes, he did.
Okay.
Sorry.
Finally, Mr. Deming, before you signed the advice rights form, did you in your mind knowingly and willingly waive those rights?
Yes, I did.
Mr. Deming, do you have any questions of the court regarding your rights?
No, Your Honor.
Do you have any questions of the court regarding anything that touches and concerns the plea?
No, Your Honor.
Are you ready to move forward?
Yes, Your Honor.
Very well, Mr. Deming. How do you plead to count one, possession of methamphetamine?
Plead guilty, Your Honor.
Thank you. If we go back to the time and date set forth in the information, Mr. Deming, what happened on February 22nd of the year 2026 that makes you guilty of the crime of possession of methamphetamine?
Because I possessed methamphetamine on that date, Your Honor.
Hey, let's unpack that a little bit. On that date, did you have contact with law enforcement?
Yes, I did, Your Honor.
What happened that caused that contact?
The people that I stayed with said that I was doing things that I didn't do to try to get me to move out of the house, and they called the cops on me. And I was sleeping, and the cops came in, searched my place, and found the drugs.
So you're at a house.
Yep.
Where was the house?
623 North Washington Street.
That's in the city of Owasso?
Yes, Your Honor.
That's in Shiawassee County?
Yes, Your Honor.
So the police came into your room?
Yep, Your
And
Honor.
then they searched your room?
Yes, Your Honor.
They found drugs?
Yes, Your Honor.
What kind of drugs did they find?
Methamphetamine.
Crystal or liquid form?
Crystal.
And what was the quantity, if you recall?
Only like a gram or so.
A gram or so, but that was your methamphetamine?
Yes, Your Honor.
And is that a drug you intended to put into your body at some later time?
Yes, Your Honor.
And no question that they were your drugs?
Yes, it was mine.
You had possession or control, and what was going to happen to those drugs, it was all up to you?
Yes, Your Honor.
Thank you, Mr. Corwin.
Court has a factual basis, Your Honor.
Mr. Kerner, do you concur with Mr. Corwin?
I do.
All right, I agree with the lawyers. The court does find you guilty. Mr. Corwin, has the court complied with the guilty plea provisions of Michigan Court Rule 6.302, subsections B through D of that court rule?
Court has, Your Honor.
Thank you, Mr. Kerner. Do you concur with Mr. Corwin on that point?
I do.
I agree with the lawyers on that as well. Mr. Deming, the court does find that your plea is understanding, voluntary, and accurate. Your conviction is now made a part of the record of this court. Let's check in with Mr. Schmidt for a sentence date.
Yes, it would be July 24th.
No more than the 17th. We got a full day on the 17th then, do we?
We do, sir.
Very good then. How are you on that date, Mr. Corwin?
I will be here.
Mr. Deming, thank you. You will be remanded to the custody of the sheriff to await your sentence date. To the extent that bond has been posted, that will be revoked. I don't know if your attorney has sent in the referral to the drug court team. If you haven't, you need to, so we can get him assessed and ready to go before sentencing. I can't promise you, Mr. Deming, what's going to happen. All I can promise is that we'll give you a fair shake and we'll take a look.
All right, thank you, Your Honor.
You're welcome. An agent from the Michigan Department of Corrections will be along to interview you. Please be honest and forthright during that interview process. You'll also receive a visit from members of my drug court team, and be honest with them too, right? Tell them what they need so they can do their job.
All right, you got it, Your Honor.
All right, Mr. Deming, thank you. Take care.
Nice seeing you today.
You too.
Okay, can you hear me?
All rise.
Thank you, everyone. Please have a seat. The next matter is numbered 251337FH, and it's captioned People of the State of Michigan versus, is it Darielle?
Darielle.
Darielle, I'm sorry. Darielle Bilby. Ms. Bilby is accompanied by her attorney, Mr. Doug Corwin. He's our public defender. Mr. Kerner is present. He's our elected prosecutor. I was given a number of documents in anticipation of a plea this morning. The documents include a plea agreement sheet signed by the attorneys as well as Ms. Bilby, and a form of advice of rights appears to have been signed by Ms. Bilby, and then Mr. Corwin, an amended information. Do you acknowledge receipt of the amended information?
I do, Your Honor.
Do you waive formal reading of its entirety into the court's record?
Yes, Your Honor.
And do you have it handy so that Ms. Bilby can refer to it if she needs to during the course of this hearing?
Again, yes, Your Honor.
Thank you. Ms. Bilby, then, if you'd raise your right hand with me. Best that you can. The other one happens all the time. Do you promise that you will tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. May put your hand down. Ms. Bilby, are you on probation or parole in this court or any other court?
No, sir.
Other than the charges that bring us together today, do you have charges pending anywhere else?
No, Your Honor.
All right. Where's Mr. Kerwin? Mr. Kerner, are you with us?
I am, Your Honor, sorry.
You're all right. Do you have a plea bargain for us?
I do.
All right. Let's hear it.
The defendant will plead guilty to amended count 3, felonious assault, count 4, felonious assault, count 6, breaking and entering with intent. Prosecutor agrees to dismiss counts 1, 2, and 5. The estimated sentencing guidelines are 29 to 57 months.
Is there a restitution component?
If there is, we will get it before sentencing, Your Honor.
Thank you. Mr. Corwin, is that your understanding of the plea agreement?
That is, Your Honor.
Let's go back to the people. Mr. Kerner, could you read the counts into the record, please?
Yes, Your Honor. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court, informs the court that on the date and location described above, the defendant did count 3, assault with a dangerous weapon, felonious assault, did make an assault upon Melissa Hallock with a dangerous weapon, to wit, a pistol, without intending to commit the crime of murder or inflict great bodily harm less than the crime of murder, contrary to MCL 75082. This is a felony punishable up to 4 years and or $2,000. Count 4, assault with a dangerous weapon, felonious assault, did make an assault upon Victor Hallock with a dangerous weapon, to wit, a pistol, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to MCL 750.82. This is a felony punishable up to 2 years and or $2,000. Count 6, breaking and entering a building with intent. Did break in and enter a building, to wit, a residence located at 8790 West Britain Road, with the intent to commit assault with a dangerous weapon there, and contrary to MCL 750.110. This is a felony punishable up to 10 years and against the peace and dignity of the state of Michigan.
Thank you, Mr. Kerner. Ms. Bilby, I'd like to go through the plea agreement with you so that the record reflects we both understand it. Would that be okay?
Yes, Your Honor.
All right. So starting with count 3, I'm told you're willing to plead guilty to assault with a dangerous weapon. We call that felonious assault, and that's a felony punishable by up to 4 years imprisonment. Is that your understanding?
Yes, Your
That
Honor.
you'll plead to that one. I'm also told you're willing to plead guilty to count 4, which is exactly the same count, assault with a dangerous weapon, felonious assault, also punishable by up to 4 years imprisonment. Is that true?
That's true, Your Honor.
Finally, there's an added count 6, breaking and entering a building with intent. That's a felony punishable by up to 10 years imprisonment. I'm told you're willing to plead to that one too. Is that correct?
Yes, Your Honor.
Mr. Kerner, is it the party's intent that all of these counts, any incarceration will be served concurrently?
Yes, Your Honor.
Mr. Corwin?
Yes, Your Honor.
And that's a pretty important point to make, Ms. Bilby, that if there's any incarceration, that they would run, all of the counts would run concurrent, side by side, rather than one after another consecutively. Is that your understanding?
Yes, Your Honor.
Mr. Kerner estimated your sentencing guidelines on the minimum to be 29 to 57 months incarceration. Did you hear him say that?
Yes, Your Honor.
Did you hear him use the word estimate when he was describing your estimated guidelines?
Yes, Your Honor.
That's important, Ms. Bilby, because the court will score the accurate guidelines as we get close to your sentence date. My point is that if the court scores the guidelines differently than Mr. Kerner's estimate, we're going to use the court's guidelines and you would not be able to withdraw your plea on that issue. Do you understand that?
I understand, Your Honor.
Also, I'm told that there may or may not be a restitution issue. I don't know, but if there is, you're going to get notice of that before your sentence date. And I guess we'll just have to see what it is before you agree to pay it, which I think would only be fair. Does that make sense to you?
Yes, it does, Your Honor.
Any questions about the terms of the plea?
No, Your Honor.
Other than what was placed on the record here a moment ago, has anybody made you any promises to get you to plead guilty today?
No, Your Honor.
Mr. Corwin, are you aware of any promises not placed on the record?
There are none, Your Honor.
Mr. Kerner, are you aware of any promises not placed on the record?
I'm not.
Ms. Bilby, has anybody threatened you or any members of your family to get you to plead guilty today?
No, nobody, Your Honor.
Are you pleading guilty to 2 counts of felonious assault and 1 count of B&E with intent because you are in fact guilty of committing those crimes?
Yes, Your Honor.
Has your attorney, Mr. Corwin, left the final decision as to whether or not to plead guilty up to you?
Yes, Your Honor.
Has he talked to you about the different choices that you have to resolve this matter?
Yes, Your Honor.
Has he explained to you that you have a right to a jury trial and all that entails?
Yes, Your Honor.
Have you concluded then, Ms. Bilby, that this plea offer made by the people and accepted on your behalf by Mr. Corwin is in your own personal best interest?
Yes, Your Honor.
Do you understand, Ms. Bilby, that once the court accepts your plea and finds you guilty, you give up or you waive your automatic right to appellate review? Do you understand that?
Yes, Your Honor.
If you wanted to appeal these proceedings, that's fine, but you would have to go to another court and ask them for permission or leave to appeal. Do you understand that?
Yes, Your Honor.
Do you have any questions so far?
No, Your Honor.
One of the forms I acknowledge receiving from your attorney this morning is captioned Advice or Rights. And when I look at that form given to me by Mr. Corwin, I see a printed name on the bottom. It reads Darielle.
Yes.
Darielle Bilby, and then there's a signature above it. Is that your signature?
Yes, Your Honor.
Ms. Bilby, did you read all the rights that are listed on that form before you signed it?
Yes, Your Honor.
And before you signed the advice or rights form, did your attorney, Mr. Corwin, did he make himself available to you to answer any questions you might have or address any concerns you may have about any of those rights?
He did, Your Honor.
And then finally, Ms. Bilby, before you signed the advice or rights form, did you in your mind knowingly and willingly waive those rights?
Yes, Your Honor.
Do you have any questions of the court regarding your rights?
No, I do not.
Do you have any questions of the court regarding anything that touches and concerns the plea?
No, Your Honor.
Are you ready to move forward?
Yes, Your Honor.
Very well, Ms. Bilby. How do you plead to count 3 felonious assault?
Guilty.
How do you plead to count 4 felonious assault?
Guilty.
How do you plead to count 6 breaking and entering a building with intent?
Guilty.
If we go back to the time, thank you. If we go back to the time and date as set forth in the amended information, Ms. Bilby, what happened on October 13th of the year 2025 that makes you guilty of that crime? What'd you do?
When my boyfriend had found out what his parents had done to me, he was very upset and he was going to confront them and possibly assault his stepdad. I had rode along with him there and he broke down their door. I was still outside at this time and I heard a gunshot go off. So I ran into the house, I ran upstairs, and there I found my boyfriend holding his parents at gunpoint. That was when I found out that he had stolen my gun. And after that, I had talked him into giving me the gun. And I then was able to get the gun disarmed and I put it in my pocket and then the cops came.
I'm sorry, are we here to give her an award for being a good Samaritan or is she here to plead guilty for a crime? Because I'm not sure, Mr. Corwin.
Your Honor, we had discussed that. She's left one part out.
So, yes, they definitely, before I had disarmed the gun, they would have been scared that I would have shot them. I take full responsibility for that. I was in a situation, there's no excuse. They could have thought I would have shot them.
Okay, I understand that. Today isn't, I did what I did because, and I'm really a good person. Today is just a day where I just need to get the facts so I can accept your plea. Listen, there'll be a time when we get together again and you can tell me, or your attorney can tell me, you know, all the positives and the excuses and maybe mitigating factors, and I'll be happy to hear that. But I'm not interested in that today. If you committed a crime, fine, tell me what you did that amounts to a crime. Otherwise, we need to move on.
Okay.
You pled guilty to felonious assault twice and breaking and entering a building with intent.
Correct.
Did you enter a building?
Yes.
Where was the building?
Their home.
Okay, what is their home?
Oh, Langsburg, Michigan.
And that's in Shiawassee County, right?
Correct.
Did you have permission to go into that building?
I did not.
It's actually a home, correct?
It's
a residence?
Yes.
Did you go into that home with an intent to commit an assault?
Yes, Your Honor.
All right. So in your mind, you were going in there to hurt someone?
Yes, Your Honor.
And how did you get into the house?
I broke into their house.
Okay, how'd you do that?
I ran into their house after my boyfriend had broke down their door.
So this is kind of like an accomplice or conspirator So your boyfriend you knew was going to break into the house, force his way through.
Yes, he did.
How did he do that?
He kicked down their door.
And you were right behind him, right?
Correct.
So it's just as you wanted him to kick the door because you guys wanted to get in. Is that right?
That is correct.
And you followed him right through just as if you would have kicked in the door. Is that fair to say?
That's fair to say.
And while in, there were two people, right? His parents, his mom and his stepdad, or his
Mom
dad,
and his stepdad. That's
mom and stepdad. And did you have the pistol? At some point, did you have the pistol?
I did.
And did you display that to the victims?
Yes.
Mr. and Ms. Halleck?
Yes, Your Honor.
Were you displaying it in a way that you wanted them to think you were going to shoot them?
Yes, Your Honor.
And do you think from their perspective that you had the ability to shoot them?
Definitely.
Okay. Whether you were going to or not really is irrelevant. We can talk about that later, but you wanted them to think you were going to shoot them, right?
That is correct, Your Honor.
You had the apparent ability to shoot them as well, correct?
Yes, Your Honor.
You weren't defending yourself?
No, Your Honor.
You clearly didn't have the Halleck's permission to threaten them with a firearm, correct?
No, Your Honor.
Mr. Kerner,
We have a factual basis, Your Honor.
on both assaults and the B&E?
Yes, Your Honor.
Mr. Korn, do you concur?
Concur, Your Honor.
All right. Mr. Korn, do you believe that the court's complied with the guilty plea provisions of Michigan Court Rule 6.302 subsections B through D of that court rule?
Court has.
Mr. Kerner, do you concur with, there's so much alliteration there. Mr. Kerner, do you concur with Mr. Corwin?
I do.
All right. I agree with the lawyers, Ms. Bilby. The court does find you guilty. The court finds further that your plea is understanding, voluntary, and accurate on all three counts, and your conviction is now made a part of the record of this state, of this court. Mr. Schmidt, do we have a sentence date?
Yes, sir. It's going to be July 17th, 2026, 8:30 a.m.
That's going to be an interesting day. Mr. Corwin, are you good on that date?
Yes, Your Honor.
Ms. Bilby, thank you. Ms. Bilby, you'll be remanded to the custody of the Sheriff's Department to await your sentence date. When you get over to the jail personnel are going to be along. They're going to want a DNA sample from you, and I think it's going to be a mouth swab. Will you do that for us, please?
Yes, Your Honor.
Thank you. Also, you're going to get a visit from the Michigan Department of Corrections, an agent. His or her job is to prepare a report that's going to discuss the circumstances surrounding your crimes, as well as your background. Drugs, mental health, education, family, all of it. So please be honest and forthright when you're talking to that agent. If there's anything good you want me to know about you, let the agent know. Do you understand?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
Very well then. Thank you so much. We'll close the record on this file.
Court calls the cases of the People versus Peter Vasher.
Read it over to the people, Your Honor.
Oh, goodness. Christina Costantino on behalf of Mr. Vasher. Judge, he was just in here.
Is this like Creature's client?
He really was, he was here.
He was here.
I talked to him.
Not a spirit.
Uh,
Okay.
If the court wouldn't mind me checking the hallway because he was here. The strangest thing.
Was Feaster going out to help you or no? Oh, he wasn't. He's just helping English.
Yes.
Oh, my bad.
Thank you. And up right here. Mr. Please state your name for the court.
Peter J. Vasher.
Thank you. Okay.
We have a problem. You had the
Yes,
bond.
Judge.
Go ahead. Let's
Yes, Judge.
that for I.
Yes, Judge, I did receive a copy of the bond violation report. My understanding is that Mr. Vasher did not report to community corrections as required for testing. It's my understanding that Mr. Vasher was released from, he was originally in Washtenaw County Jail. He was then transferred to Wayne County Jail, and that he was just released from Wayne County Jail yesterday. It's further my understanding that he did speak to community corrections yesterday. He has indicated they did tell him to report to community corrections. Unfortunately, he has indicated that his car broke down as he was going to community corrections. I did, Judge, I called him. He was clearly on the side of the road with a broken down car when I spoke with him yesterday. It really sounded like it, Judge. I mean, cars driving by, maybe some honks, you know, it sounded like it. So, so Judge, long story short,
Oh, this is not short. Go ahead.
I did speak with Mr. Vasher. He is aware he needs to go to community corrections. He has the funds in his pocket, which he showed me today, to pay for the testing. He's indicated he will go across the street today after this hearing and test as required. So we would ask the court to give him an opportunity to do that. He is 68 years old. He has a slew of health conditions, including COPD and cirrhosis of the liver, that incarceration or continued incarceration would make significantly difficult for him. So we'd ask the court to give him an opportunity to go to community corrections and test.
But he just got out yesterday. Well, he got out and then, okay. I'm gonna.
Did you get out of jail yesterday?
8 o'clock at night.
Okay.
So that's a yes.
So,
All right.
yeah.
Okay. Sir, get yourself over. I'm gonna get yourself over to community corrections, okay? And get yourself set up. Got that? Know where they are? Right across the side. That's right. What road did you break down on? Huh? What road was your car on when it broke down? 94. Wow. Okay. Well, you got here safe. Don't worry.
It did sound like a judge.
I heard honking and all right. And then you want this adjourned?
Yes, Judge. I was just appointed to Mr. Vasher's matter yesterday, so I do
11th.
discovery.
11th work for you?
Yes, Judge. That would. Thank you.
Both of your matters are adjourned to the 11th. Get yourself over to community corrections. Okay? I'm there. Pardon? I said I'm there. Okay.
There.
Very good. All right. Take
Thank
care.
you very much, Judge. All right, we're all set.
Thank you. Court calls case for versus Warren Abbott.
Assistant Public Defender's Advocate. On behalf of Mr. Warren Abbott, I believe, is he on Zoom, Judge?
Yes, he is. Mr. Abbott, state your name.
Excuse me, everyone.
Thank you.
Can you hear me?
I can hear you.
Say, by the way, may you place the camera on my floor. You will see a core of an apple.
Okay.
That is how much they've been starving me. I've had about 10 to 15 meals since I've been here. This is a county system. I have not been to jail.
Okay. I'm sure we'll have your attorney look into that.
The first part of this system is called jail. The second part is called the county. And after that is the state. I have not been to jail.
Okay. We'll get all of that rectified. You're asking for a forensic evaluation?
I am, Your Honor.
Okay. Forensic evaluation will be ordered. I'll set a competency hearing date, and I've signed the order for August 27th, 2026, 9 a.m.
Okay.
Bound continued. Thank you, Mr. Abbott.
He's good.
Court calls the case People versus Erica Maxwell.
City Blood Center Dovey Lieb on behalf of Ms. Maxwell.
Yet.
Say your name?
Erica Maxwell.
Who's this? She has a bond violation. All right, what are we doing on this case?
I would like to set the matter for preliminary examination, and I am prepared to address the bond violation.
Go ahead, address the bond violation. We'll see what we'll do.
Your Honor, with regard to the bond violation, Ms. Maxwell will admit to it. She does tell me that she doesn't specifically recall drinking. She does believe she has some mental health issues that may be a factor. She does tell me that she's made contact with Catholic Charities and left a message hoping to engage in their intensive outpatient program. He asked the court to consider letting Ms. Maxwell stay out with a scram in a home confinement tether. She's explained to me that she suffers from sarcoidosis, which is a medical condition that requires a weekly injection that has to be refrigerated, that she's concerned she may not be able to get in the jail. She also indicated to me she has concerns regarding a compromised immune system. So I would ask the court to consider permitting her remain out primarily because of her health concerns.
Response from the people.
Your Honor, we will leave it in the court's discretion. we just lived on several, or at least two missed, one missed test that I'm seeing, and then several non-compliant. So that would be our concern, but
She's blowing positive, and I mean, it's not like they were low levels. As she was coming down off of that, and then missing tests and the like. I understand everything that counsel's saying. You wanted this set for preliminary examination?
Yes, please, Your Honor.
All right. Your
And discovery is complete.
discovery is all complete.
Yes, Your Honor.
People have their witnesses available the 9th. All right. Preliminary examination in this matter will be set June 9th, 2026, 9 a.m. before Judge Garwood.
yes.
Judge Garwood. At this time, given the violations, defendant's bond is revoked, defendant's remanded.
Thank you, Your Honor.
Man, you hate to see it. Right? You hate to see it. They put you on bond. They tell you don't do X, Y, and Z. You don't go out and do X, Y, and Z. Oh my God, I just thought of something. Let me double check something here real quick. I do want to let everybody know I appreciate everybody coming by tonight, and we are not finished right now. I do have things set up, I believe, to redirect over to our little friend Wolfbot, who is doing a Throwback Thursday right now, showing a whole bunch of court content from Thursday 1 year ago today, which is not a Thursday, by the way. Just throwing that out there. I think that, what would it have been? A year ago today? Would that have been like a Wednesday, I believe? Does that sound right? Would that have been Wednesday? Oh my God. I had all this set up and then stream chat crashed. What you gotta do? There's some chat for you, ladies and gentlemen. Thank you so very much, everybody, for hanging out in chat. It does look like I have that stream set up. We are redirecting over to Wolfbot, and I do happen to know Wolfbot is playing some pretty... Judge Dad is currently on deck. I do want to make sure that we have the link for those who may be interested in going over right now and not listening to me jaw for the next 2 minutes, because I am going to jaw for the next 2 minutes, especially jaw about these very special people right here. Oh my dear Lord. Thank you so much, my dear friends, coming out, hanging out, and helping tonight, especially Marty Duvall, Kiernoff, all these jewels and gold coins and thumbs up. It's a party, man. It's a party. Thank you, Donald, for showing up. Thank you, Mortimer, for showing up. Mazzy, I think we had a bunch of new people show up. I don't even remember their names right now. I know Meemaw was one of them. That's a name that stands out to me for certain reasons. Ladies and gentlemen, thank you for coming by. I will have lots more just like this. Same wolf time. Hey, there she is. Old nurse Bossy Meemaw. Something like that. Yeah. There's lots more like this tomorrow night. Same wolf time. Same wolf channel. There's court every single day that there is court, and even when it doesn't seem like it's a court day, usually there's some court going on somewhere, somehow. And if it's not, ladies and gentlemen, I have a huge archive. And this is the reason we have a whole nother channel, is because the archive is so expensive that I can't show it all here. But tune in for my regular daily drops, 4 a.m., 12 p.m. And then the live at 8 p.m., all Central Time. It's every 8 hours of the day. I'm a crazy person. I know. I shouldn't do it. I am your lone Wafuso. I appreciate you. And I am out. I mean, you don't exactly have to go away because we are redirecting and there's going to be like a whole chat going on over there. And I'm going to leave that playing until I'm ready to go to bed. I think I loaded like 23 hours worth of court in over there. I don't even know. Let's go check it out. Let's see what Judge Dad's doing. I'm done. Go. Bye. Killer. Killer. Bye.